can we go straight to the judgment at paragraph 49, where the case management... Oh, I'm sorry, my lords.
49.
Hold on, where the case management discussion starts.
Yes.
Two extracts from the case law. One from Conversant, where Lord Justice Floyd recognised that a stay would only work if there were proceedings on foot elsewhere, which would result in an adjudication on the offers made by the parties and determine the terms of global friend licence, or at least some licence which would extend to the UK. Of course, that's the case here now that the Chinese courts have decided to exercise that power. But the more important paragraph is where the learned judge cites from the Supreme Court in Unwired Planet.
Before we go,
oh, I'm sorry.
So I'm in answer, I think, to a point that was in my mind before lunch. Paragraph 49 reminds me that you had put your case in more than one way.
Yes.
So it was the whole thing, and if not the whole thing, the
yes.
flat. I understand. Okay.
I'm sorry, my lord. I should have explained
No,
it. The judge had acknowledged that, and our point was really that if Fran, then probably the others fall in with it. For obvious reasons, but my lord has that point.
On the rebound.
Exactly. Yes. Exactly.
Okay.
So turning to paragraph 51, where the learned judge cites from the Supreme Court in Unwired Planet, obviously correctly, but the key point is there, the Supreme Court says that the jurisdiction in relation to case management, temporary stay may be ordered where there are parallel proceedings in another jurisdiction raising similar or related issues between the same or related parties, where the earlier resolution of those issues in the foreign proceedings would better serve the interests of justice than by allowing the English proceedings to continue without a temporary stay. And that's a quotation from Reichl. And we respectfully submit that that is the key test. It's all about time, whether one is concerned with the earlier resolution in the other forum. So the judge then went on to consider the framework and the arguments. And I don't think I need to spend a lot of time on those, because with respect, we agree with what the judge concluded and found in paragraph 75 onwards to 114. Our issue with the judgment is not those points which deal with the risk of irreconcilable judgments, timing, whether the Chongqing court will settle a cross-license, a license for other devices, the lower royalty rates and the relevance of French law point. We don't debate those. Our point is the extent to which those were the decisive considerations in the question of timing of the cases, rather than in whether the relevant court should determine the matters at all. And the judge picks that up at paragraph 115 of the judgment. That's Core Bundle 134. And he turns immediately to a discussion which is a slightly broader question about whether SEP owners should be allowed to select the jurisdiction for settlement of FRAN terms that suits them best. Now, of course, that is an issue. It's the background of this case. But it's not the central issue in relation to case management, because the central issue on that is whether, having, on the assumption that there are cases going on in parallel, it is right for one of those cases to await the decision of the other case. So he is right in the observations that he makes, but we say, insofar as that's regarded as relevant, not right to take that into consideration. So then he makes a distinction correctly at a paragraph 119 and 120 between forum non-conveniens and the case management stay. But when he comes to characterize the test applicable to a case management stay, he does not do so in terms of the Supreme Court in Unwired Planet, namely the question of whether or not one set of proceedings should go ahead earlier than another set of proceedings, but by reference to what he describes as a conclusion on the balance of justice.
I'm a bit puzzled by this. I mean, you seem to be assuming that if it is right that one case should go ahead earlier than the other, it should be the Chinese proceedings which should go ahead earlier rather than the English proceedings. But why not the opposite? Why should the Chinese proceedings not await the outcome of the English ones?
Well, our submission is that the Chinese proceedings are likely to determine the bulk of the license because they relate to Chinese patents likely to be effective in China in any event. And the bulk of the commercial activity in relation to the purported license, the proposed license, is activity taking place in China. Very limited activity is taking place in the United Kingdom. And in our respectful submission, if one is choosing...
So it all comes down to which is the biggest market. But that's the same argument that's relied upon for Forum.
It's not the same argument in this sense. Well, the justification for the Chinese proceedings going ahead sooner is the same justification. That's correct. But the test of whether it makes sense to go ahead with one first and then the other is a different because the court needs to consider.
But as I say, assume it makes sense to have one first and for the other to wait, why shouldn't the English one be first?
Well, what's contemplated in the English court proceedings going ahead is, in any event, a very costly set of English proceedings. The Chinese proceedings
are 3 5-day trials on technical issues, which you accept are almost certainly going to be irrelevant in the scheme of things. Yes.
Well, I don't quite put it like that. I accept that on Nokia's case they're not irrelevant. On Nokia's case they're absolutely essential because they're, as we've been through before, an essential precondition to get the English court to be doing this in the first place and then enforcing the license. On our position, I'll come finally to where our position has wound up very shortly, they are not essential. But the central point here is that the learned judge looked at this in terms of multiplicity of proceedings. What he didn't do in our respectful summation is look to see the question of which should go ahead first. He says in paragraph 122, disadvantages inherent in a multiplicity of proceedings provide a very strong argument in favour of FRAND terms being settled in one tribunal, but they do not help in resolving which tribunal that should be. Well, we respectfully submit that's not looking at it in the right way for the purposes of a case management. The right question is which tribunal should go ahead first in these circumstances. And in our respectful submission, he did not apply the test in the Supreme Court summary of the test in Reichhold of considering whether or not it would make sense for the English proceedings to await the determination of the Chinese court.
If the question is which court should go ahead first, why is not the logical answer the court first seized?
Because the court first seized may only have been first seized because a litigant rushed to the door of that court. Bearing in mind that these proceedings were issued on the day, I think, or the day after of expiry of the
previous license, and what's wrong with that? It's the logical time to start.
I'm not criticising it as such, but it could as easily have been the other way round. In my respectful submission, if
so, what's the test? Which course is fastest? So you go to the court with the rocket docket.
The court that, in my respectful submission, what the court needs to do in deciding whether there should be a case management stay is to look to see...
Well, why don't we all go off, send this all off to Marshall, Texas? They're very proud at speedy patent dispute resolution. But so let's assume they could do it quicker than England or China. So we send it off to Marshall. Why not?
But Marshall, Texas probably would say, well, because we're in America, without the consent of the parties, we're not going to settle a global license. Because one of the things that the United States courts have done is that they have taken a more modest approach, save with consent of the parties, to settling global licenses. The reason we're in this battle at all is because...
So this is in reality nothing to do with speed whatsoever. This in reality is because your clients want this dispute determined in China.
Yes, and because Nokia...
It's nothing to do with the speed. Their position will be the same, even if the Chinese courts were much slower than the English courts.
But that's exactly the position that Nokia takes. Nokia takes the position...
Yes, of course, they want the dispute determined here. So it all comes down to how do you decide when each side quite reasonably wants its preferred forum to hear the dispute?
My Lord might say, because it's only relatively recently that the proposed pleadings amendments have been put forward, that we were the ones who went, to use the term of the court, direct to FRAND. We invoked the jurisdiction that would settle terms for a global license that could and if Nokia wished, would settle terms for a global cross-license without the need for any patent proceedings to take place at all, because the Chinese jurisdiction provides for that. And we were the first to invoke a jurisdiction which would not simply give a yes-no answer to whether or not an offer made by Nokia was FRAND, but would actually determine FRAND terms. And that is a jurisdiction which is in the middle, subject to Nokia's jurisdictional challenges, of proceeding with this. It has accepted jurisdiction to do that. It has accepted that it is appropriate to do so, and my lords see that in the bundle, and it is likely to do so within reasonable time and reasonable cost for the majority of the market. And in our respectful submission, in those circumstances, it makes more sense for that process to be allowed to continue while in the Chinese courts, rather than have the costly process in the English court in parallel at the same time. Now, my lords may say, well, you know, Nokia will take exactly the opposite position, but there is a genuine asymmetry in the position here. We have been the ones who have gone directly to FRAND, tried to sort the matter out in a court which has established jurisdiction to do this, and Nokia doesn't want that to be done. And so in our respectful submission, for timing reasons, convenience reasons, not foisting unnecessary trials on the English court reasons, that the sensible course is for these proceedings to be stayed pending the outcome of the Chinese proceedings. And my only point on the judgment is that that is not quite the way in which the matter was looked at by His Honour Judge Hacon. He looked at it more as though one was doing a forum non-convenience test rather than doing a temporal staging test. And that is why, or one of the reasons why, this court may consider it appropriate to take a different view.
You could have asked this court, by giving undertakings, whatever, to case manage the proceedings so that this court went straight to FRAND.
Well, we could have done, but since it is my client's position that it is appropriate for FRAND to be determined in China in the way that they have put forward, in circumstances where they consider that to be the right way, to then give an undertaking to this court to say that there would then automatically be a substantial and costly trial in this court as well, it would be a puzzling thing to do. My clients don't want to be here. They don't want to have these proceedings against them. They haven't brought any of these proceedings in the United Kingdom.
China, so you know, each is in the same boat.
Absolutely, absolutely. But I was only answering my Lord Justice Phillips' point that we could have given an undertaking. Equally, the point applies to Nokia. Nokia could have given an undertaking to say we're quite content to have FRAND terms determined in the Chinese courts. They can still do that now.
I'm conscious that we're taking you.
Yes,
beyond
I'm done
saying this, but
on this.
Well, in the end, the judge thought it was a draw.
Indeed.
And that it didn't take matters beyond his determination on the jurisdiction issue. But just in a word, what is the incident of this scenario that you say takes it beyond a draw?
Well, we say
what's the main thing? Is it all based upon procedural advantage and?
It is based on cost and convenience of having additional English proceedings in circumstances where there is a realistic prospect.
Right, because all the other matters are matters which will have been taken into account if the exercise on jurisdiction has been properly performed.
My lord, yes.
Right. So really we're left with those issues of time and expense and duplication and so forth.
My lord is absolutely right, and indeed my lord expressed it very well in saying, well, the alternative is that the proceedings continue in parallel, yeah. And
right. Well, I've now understood where this gets us. So when you've, as it were, expanded into other areas, which may very well be good arguments in relation to the jurisdiction aspect of it, that they don't recycle into the stay.
No, they don't. Once it's accepted that that's the option, it's either parallel or series, if I may put it like this. We respectfully submit that series adjudication is appropriate. Under case management stay, one is considering series adjudication because that is the alternative to parallel adjudication, and it makes more sense for that to be determined in that way. That's the number there. So the final point is just to answer my Lord's question on other jurisdictions, which you raised during the course of argument. Does this impact on other jurisdictions? The answer, of course, is no, it doesn't necessarily, but we have put forward a proposal to Nokia, which my Lords will have seen in the annex to the further submissions dealing with the question of arbitration, which would, of course, remove the need for all of those other proceedings. Essentially, the bones of that proposal are the matter would proceed in China as quickly as possible, English proceedings are stayed, the other proceedings are stayed, and if with the Chinese proceedings, Nokia is dissatisfied with the outcome as it applies to the United Kingdom or the EU, then they could come to this court and say, well, we want it essentially redone. Now, that is a sensible, in my respectful submission, proposal. It means that one would not be causing proceedings to be pursued unnecessarily, and it would be a way of removing essentially the Annex A to our note proposals from continuation. Now, Nokia may not want to take that course, but we are perfectly content to take a course which would enable the twin objectives to be achieved. One, resolution in China, which is the majority market, but also to provide for the possibility of what's been described as local rate setting in England and for the EU. And in my respectful submission, that is a practical way forward. Your Lordships may say, well, it's not perfection. Nothing is perfection in this field, but it's fair, it's balanced, and it means that neither side is doing what might be called jurisdictional excess.
Thank you.
Unless I can assist my Lords further on.
No, thank you very much indeed.
Well, just before Mr. Saunders goes to his feet, may I correct something that I said earlier this morning in response to a question from my Lord Justice Phillips about the date at which the various tests are applied. In respect of service out, gateway and the proper place are both decided at the date when the application is made for permission to serve out, and then on an application to set aside service out, evidence can be taken into account as to what was the appropriate point, what was the appropriate forum at the point when permission to serve out. So you should got it absolutely right, and I'm afraid I've got it somewhat wrong there. On UK defendants, a subsequent stay application is judged as at the date the application is heard. And of course, just on the question of proper place for what, in this case, was the proper place for the narrow question of whether Nokia's proposals were frank. The proper place, the case now being advanced is different, which is asking the court to settle terms, which it wasn't doing at that point. Maybe a critical difference.
Yes.
My Lords, can I just pick up that final point very briefly?
Yes, can I just do a bit of case management at this stage, which is, I'm sorry that your time has been slightly eaten into. Will it be convenient for you to have dealt with your client's case by 10 or 4:15?
I think so, my Lord. Many of your Lordship's questions actually touch on.
Well, I have in mind to allow the appellants a quarter of an hour in reply, if that should be possible, and we won't sit after 4:30. So I think we see.
Message received.
All right. Well, we'll try not to obstruct you.
Well, my Lords, can I just by way of that point, the final point was made about the point on timing. Can I just give you two references in Dicey which may assist? It's paragraph 12-032 and paragraph 12-034, and those timing points are both implicit. When one sees the text there, it may assist my Lord Justice Arnold. My Lord, my learned friend Mr. Alexander said that Oppo does not want to be here. Well, it doesn't have to sell products in this jurisdiction. It doesn't have to offer products via its website. The third defendant is accused of offering products via its website into the United Kingdom and admits joint tortfeasance with the operator of the website. Now, one of the aspects of this case which my lords may not have seen given us slightly filleted evidence on appeal is that it costs an extraordinary amount to do the underlying research and development to develop these inventions. The evidence below was that Nokia has spent more than 129 billion euros on research and development over the last 20 years, and in 2020 alone, 4.1 billion euros. Now that has led to what we say are a large number of inventions, and it's led to the grant of a large number of monopolies in a large number of different jurisdictions. And the question ultimately becomes one where if a party does not have a consent to work the inventions that Nokia has been granted as monopolies, then Nokia is entitled to seek relief against that party. And so that is the nature of the action. In the United Kingdom, it is an action for patent
yes, but
infringement.
subject obviously to Nokia's undertaking to grant licenses on FRAND terms, which are designed both to ensure that patentees get a fair return for their inventions and also to ensure fair market access by implementers.
My lord, we absolutely accept that, but it isn't a necessarily part of these proceedings. It would be open to a defendant to say, you've sued us on 3 patents, actually they're all invalid. That's our defence. If you lose on all 3, there's nothing left in this case. And that rather underlines the fact that this is an action about property rights, fundamentally. Well, I'll take you to the pleadings in a moment, but what OPPO do here is they say not only are the patents invalid, your monopolies are not valid monopolies, but also we say that we're, as a positive defence, OPPO say we're in the class of beneficiaries envisaged by the ETSI rules of procedure. As I say, I'll take you back to the pleadings in a second. But it is raised by way of a defence in the English action to a claim for patent infringement. Now, the action in China is a fundamentally different thing because it is a freestanding determination of FRAND. And it is a freestanding determination of Chinese FRAND. I'll come on to why that's significant in a moment. But my lords may be asking yourselves, why are we having this fight at all? The reason being that, on the whole, China gives much lower rates. Now, so there is a fundamental distinction between the basis of the Chinese jurisdiction, where the court has just engaged with a freestanding action for FRAND, and what is happening in these proceedings, which are where the defence is raised in response to a claim for infringement. Now, it would perhaps be possible for a party in this court to say, all I will do is commence an action for declaratory relief to declare the terms of a FRAND licence. Under those circumstances, you could see how the forum convenience arguments might be rather more acute, because there, the patentee would be seizing the English court with a determination which is very, very similar to the basis on which the Chinese court is carrying out its determination. But that isn't this case. This case is a claim for infringement. In its defence, OPPO says that the patents are invalid. And they say they're also entitled to a licence, because they fall within the class of beneficiary that ETSI envisaged. So, my lord, it's just important to have those distinctions in mind, because it isn't quite right to say that the 2 actions are mirror images of each other. They're not at all. And that is one reason why, when the case went up to the Supreme Court, the jurisdictional issues and the issues of comity and everything else that were argued up in the Supreme Court on Wired Planet could be resolved, because when the patentee, when the implementer actually gets to the point where a patent is found to be valid or infringed, they're put to an election. They could fall on their sword and so will submit to an injunction, or they could be enjoined. In which case they've got to stop infringing the patents, the consequence of which is that standard essential phones can't be sold in this jurisdiction. So that's one option open to them. Or they can buy the license, for which is a consent that operates under the Patents Act, to mean that going forward, for the term of that consent, there is no infringement going forward. And that's the election that the implementer is put to. There's no such election in the Chinese proceedings. They're of a fundamentally different nature. And that, when my lord should appreciate that, actually the distinction between these two different actions and what to a certain extent is what we would characterise as a slight sleight of hand in the way that the Chinese proceedings are described. When you appreciate that actually you're not dealing with the same things, it's quite easy to see why the proper characterisation of this case is as a patent infringement action. And it doesn't mean that all patent infringement actions will necessarily be seized in this court. We could have a very full argument about a freestanding claim for declaratory relief for Fran without any infringement action. But that is not this case. My lord, so those are some fundamental points that we would say at the outset. Can I just pick up the position in relation to arbitration, which was my Lord Justice Arnold's question? So I should say we apologise for not having got back to you earlier. As I said earlier. We do have a note, so we've produced an updated version of the note with some track changes. I won't take you through that now, but we can hand it up.
Can we see it?
Yes, of course. Yeah, that's all. Well, until what we've done is just add some track changes onto that, just to have our corrections there. Hopefully pretty minimal. But you've got that. I don't propose to address you on it unless one of your friends have some concerns about it. My lords, the position in relation to arbitration. Can I deal first with the historical position? And you'll see that in, if we could go to the supplemental bundle, tab 31. Hopefully I can do this in open court just by identifying the pages to read to my lords. And then you'll see the parties' positions as they developed. So it's supplemental tab 30, supplemental bundle, tab 31, page 305 in the PDF. So that's the initial proposal you'll see there. There were two options proposed. Then just over the page, you'll see there is a draft agreement. On page 307, you'll see the rules of arbitration that were suggested, and you'll see the seats, suggested seats. You can then turn through. The OPPO response is at 327, starts at 327 and runs through to 328. I'll just invite my lords to read the two paragraphs on 328, just in the middle of the page, which set out OPPO's response in relation to Nokia's proposal. And then 333, you'll see that there is a further proposal by Nokia, which is material to this. The response to that is at 334. And again, I just invite my lords to read to yourselves the second and third paragraphs, the ones, so the one that begins moreover and the one that begins oppo. And that sets out the true position in my submission. And
that's all, as you rightly said, historic. So what is your client's current position?
So, my lords, So I should say our general position is that Nokia is open to arbitration, as international arbitration, as a way of resolving disputes over licenses. These proceedings, if one were to hold up all of these proceedings at the stage that they have now reached, the question is one of timing to a certain extent, because Nokia is being kept out of what we say is a license fees for acts for people working on patents. The litigation in here and in Germany has been running for almost a year now, and in these proceedings we're seeking relief for what we say are valid and infringed patents. There are two SEP decisions due to be handed down in Mannheim.
Is the short answer to my Lord's question, in general, yes. In this case, no.
Well, not in this case, but at the stage we have now reached in this dispute.
I mean, can we just cut
my
to the
Lord,
chase?
I can cut through, yes, of course.
Yes.
I should also say that one of the other reasons why there's a bit of an issue is that generally speaking, implementers want shorter license agreements now, so they often run for 3 years. That's a common time period. If you get to a point where it takes a long time to start an arbitration, so there's going to be an 18 to 24 month delay starting now, we may well end up actually only concluding that after the end of the period where the license applied, and then we find ourselves, as it were, behind the curve in sorting things out. So my Lord is quite right to approach the position, but that's where we stand in this litigation. So my Lord, I mentioned that I take you to the pleading in relation to the question of characterisation. Can I just pick that up? That's the core bundle tab 14. So there are several
Sorry, I
defences.
missed the reference.
I'm sorry, so it's core bundle tab 14, and you want page 170 in the PDF.
Yes.
So there you see the response to, so there's an allegation of infringement with the particulars of infringement, and this is the oppo defence. So paragraph 1 says the patents are and have at all material times been invalid, and or the OnePlus defendants have at all material times and have at least since 30th of July, and so they plead the various dates, been within the class of beneficiaries of clause 6.1 of the ETSI IPR policy, and or a license has already come into effect for the reasons set out below. Now, both of those are French law pleading, because they say
I'm sorry, I've missed the paragraph number. Can you give me that?
I'm sorry, so it's actually, it's a rather long, so it's paragraph 9 I, little rent says on page 170, page 6 of the pleading.
Yeah, I've got it, thank you.
So they plead that they're in the class of beneficiaries envisaged by the ETSI IPR policy. That's a French law pleading of a contractual defence to an infringement action in the English proceedings. And then if you look at...
Is the corollary of little 1 under paragraph I that for 3 years they've been paying for patents that weren't valid?
For those, if they win on that, that's... Well, they haven't, so...
I mean, is it the corollary of what's being argued there, namely that, all right, we've been paying large amounts of money to use your patents, but actually they're not valid?
Well, it isn't quite...
Doesn't work like that.
No, because the licence was a portfolio licence of all the standard essential patents, whereas we've asserted 3 patents in these proceedings. So if they clear the 3 away, that may have an impact on the overall sums, but it's not. It doesn't necessarily mean it doesn't mean that the whole case stands or falls on the 3. I can't remember the exact figures. They're in evidence, but they're something like 20,000 different families, I think. So there's a sort of Red Army issue. They will, if we fall on the 3, then there are others potentially out there that we could succeed on. So, my Lord, so they're running the French law arguments. You turn to page 10 in the pleading, so that's in the PDF, page 174. And then you'll see 20H. So they plead expressly it's a matter of French law. They say that Clause 6.1 creates a stipulation pour autrui, which is a doctrine of French law, a bit like a third party, a contract for the benefit of a third party. I'm always told off when I refer to it like that. It's obviously a French, but that's the anglicised equivalent. And then they go on to say, to talk about Optus and Apple, and then they say that they're entitled, that they're having commenced the Chongqing action in 20J, that's good enough for Optus and Apple. And then 20K, they say, in any event, further or in the alternative, they're the beneficiaries of a licence under French law, such a licence being a contract governed by Articles 1101 of the French Civil Code, which do not require the parties to agree on a predetermined price. So this is a sort of amorphous French contract that has sprung into existence, and they say on their case gives them a consent. Now, that is the usual defence of an implementer in these cases. The argument in 20K has been run in the Phillips case, and the argument in 20H was the one, amongst other things, that was run in Conversant. What is a little different in these proceedings is they also say that the Chongqing action is good enough to qualify them as a beneficiary under Clause 6.1 as a matter of French law, because they say that that's a determination that's good enough. And that's the issue that's going to be determined in due course in the trial that my learned friend talked about. So there's an earlier trial following the technical trials to decide if this is right or wrong. If they're wrong about that, we'll be asking for an injunction at that point. So we may not even get to Frand in the English proceedings, because if they don't fall within the class of permitted beneficiaries under the ETSI-IPR policy, they have no defence other than knocking out the patents because they're invalid. So if we survive with a valid and infringed patent, and we're fairly confident about that because we've won on one of them in Mannheim previously in Germany, then
that was just infringement, wasn't it?
I think it was. My lord, yes, you're quite right, because it's a bifurcated procedure. We having the position is that if we're successful on that, then we will say that the usual relief follows. So it's for them at that point either to submit to an injunction, or they can undertake to the court along the principles in Optus and Apple and say that they will buy a consent on terms that the English court approves. And that is the way that the jurisdiction works in England. They're put to an election. Now, it is in the past, some implementers have decided to accept the injunction. That happened in the TQ Delta case that came up to this court, and Lord Justice Floyd said that there was nothing left in the case. Once they decided to submit to an injunction, that was it. That's the end of it. So I've got nothing. I have no more action in the English before the English courts. And in my submission, that entirely reinforces the fact that this is, by a proper characterisation, an English property right. Frand arises when the defendant wants to assert that they're within the class of beneficiaries, and following Optus and Apple, and obviously that's a matter that may come before my lords in due course. It is going to come before this court, but it may come before my lords. Mr. Justice Mead said the proper procedure in the English court is for you to give an undertaking to the English court once a patent has been found to be valid and infringed. You've got to give an undertaking that you will take a licence, and then that can be sorted out. But that's the point. So that's the point of election, and you have to decide. So it is entirely open to them. If they don't want to infringe our patents here, they don't have to. And that's an end of the English action. Now, my lord, so we say that all of there's a false dichotomy underpinning much of this, much of the debate that my lords have heard this morning. We're not comparing like with like. They're fundamentally different actions. And that is why we say that as a matter of characterisation, Lord Justice Floyd in the Court of Appeal in Conversant was absolutely right to say what he said about the nature of these cases. And the Supreme Court, as my lords have observed already, endorsed that, albeit that it was obiter, because there was another basis on which to decide the appeal. That doesn't, my own friend Mr. Leighton seems to try and suggest that there's some distinction that the Supreme Court was drawing there. All they're doing is saying that in this case the issue doesn't arise because we've got another way through. My Lord, now, it's also important that my Lords are absolutely clear about what is happening in China and the evidence below in relation to the Chinese proceedings. As currently pleaded, the Chinese rate-setting claim does not ask the Chongqing Court to set a cross-license. And as the learned judge rightly concluded at paragraph 87, he said this is unlikely to have been an oversight. And now, why is that significant? It's significant because Nokia's undertaking to Etsy, which is a French law undertaking, is conditional on reciprocity. Because the Etsy rules permit Nokia to say that we will only grant FRAND licenses where an implementer also licenses Nokia back. And so there's in fact a box that you can tick on the form to permit that to happen. So the cross-license, there is no obligation, freestanding obligation for a FRAND license. Absent a cross-license, it is conditional. The Chinese action, on the other hand, is presently constituted as a one-way license of Nokia's patents. So it's not the same as the French law undertakings that we're relying on here, or that Oppo's relying on here.
Can you explain the significance of this? Because I'm still struggling to understand that. And I understand perfectly well what you say about Etsy giving you the option of making it conditional reciprocity, and you have exercised that option. Fine. But we're not concerned with the cross-license in the English proceedings as currently constituted either.
Well, my Lord, what the license that we're seeking to have approved is such a license. So that is the one on which we're seeking declaratory relief. So it is live before the English proceedings. Now, and the way that, given the defence that is run, that the defendants are within the class of beneficiaries envisaged by the Etsy IPR policy, that, in my submission as a matter of law, means that they take that subject to the reciprocity condition. So these are issues that are live before the English proceedings. They're not the same, it is not the same in China. So it is presently a one-way license from Nokia outwards. The second point is the Chinese rate-setting claim on its face only covers Oppo branded devices, not OnePlus and Realme branded devices, which are the subject of the action in the United Kingdom. So we assert infringement against those. The Chinese rate-setting claim only relates as drafted to the Oppo branded devices. Oppo's evidence before the judge was that it would, if necessary, take steps to remedy that point, but it hasn't actually taken any steps in China to do anything about that. And it is now said in Ms. Liao's third statement, the Latin Marshall statement, that they intend to deal with that.
Yeah, but that was the paragraph that your side's urging I declined to admit.
Well, my Lord, because as well the ground is shifting. So there is a real issue about whether that's admissible, and my Lord's already ruled on that. But in any event, we don't take much comfort from an intention in that way. The third point is that the evidence below was that the rate-setting claim will not consider Nokia's offers and will not consider whether they're consistent with our FRAND undertaking to Etsy. That engages questions of French law. The fourth point is that the Chongqing Court will apply Chinese law when determining the terms of a global FRAND license. And I can just give you the references for that. So that's Dr. Zhong, which is Oppo's expert, supplemental bundle tab 4, paragraph 22, and then she cites the paragraphs 8 and 9 and Article 7 of the Chinese Civil Code, which is all about the Chinese law principle of good faith. And then paragraph 20 in that, and then she says that the precedents apply Chinese law. Over to tab 7, You then have Professor Lees, who's Nokia's expert, paragraph 19 of his report. He says that it is Chinese law that is applied, cites the decision in Huawei and Interdigital. So it was common ground below between the experts that it's a Chinese law determination in China. And Ms. Lau's, who's Oppo's Chinese lawyer, so she's the advocate for Oppo, didn't disagree with that in her first statement. She gave references to that and some of the other evidence, and we've dealt with some of that in our skeleton at paragraph 35. So the decision in China is not, in my submission, the same thing that is going to be happening here. It is Chinese friend. And so, again, one of the things that my lords need to bear in mind is that there are substantive differences. We are not talking about the same dispute. We're talking about a separate
I understand the points that you make about differences between the two actions, but what's the problem about Chinese law?
Well, my lord, there are substantive differences.
Yes, but what's in a sense, what's wrong with it?
Well, we don't say that there's anything wrong with it as a matter of Chinese law. If Chinese law is...
No, but what law ought to be being applied?
Well, we say French law, because the undertaking is given to ETSI, and that is governed by French law. I'll come on in a moment to the point which my friend was making, which is that this is not an issue of French law. It's my submission that's quite wrong. So when one's looking in particular at issues about non-discrimination, you apply a French law approach, and that's exactly what the Supreme Court did when it decided the proper approach to non-discrimination in the Unwired Planet case. What it was doing was construing a French law contract in accordance with French law principles. It looked back at the negotiation history in order to help construe the provision. I'll make that submission good in a second.
Right, thank you.
So the reason non-discrimination matters, or potentially does matter quite a lot, is non-discrimination is the aspect of FRAND which effectively says that you can't charge this person one price and that person over there a different price. Now the question is, do you approach that by a chase to the bottom, so all licenses have to be at the cheapest price that you've ever offered, or do you have a more general approach to non-discrimination? And that was one of the issues that was live in the Supreme Court, and that was resolved by the Supreme Court. So we have that there is law in this jurisdiction on that, and it is not the same, we submit, as the law in China.
Well, how do we know it's not the same as the law in China? I mean, perhaps more relevant question is how do we know what French law is on that question? And it's undoubtedly the case that in Unwired Planet, the courts in this country decided that the test was general, not hard edge. So you're not asking yourself, has there been no discrimination at all? You're asking yourself, has there been unjustified discrimination? Because there may be circumstances in which discrimination between licensees is in fact justified. But how does one know that that's actually as a result of applying French law? True it is that the courts in Unwired Planet all proceeded on the basis of this is a contract subject to French law, therefore we construe the contract in accordance with French contractual principles of construction. But once you've interpreted the contract, you're still left with the question of, well, what amounts to non-discrimination?
My lord, yes, and in any particular case, you've got to, as it were, crunch the numbers.
And there's no French case law on that. But
No, there isn't, but actually it's a question of principle as much as anything else, because obviously what the Supreme Court has done in Unwired Planet is set the correct approach. So it has ruled on the correct approach to non-discrimination in this jurisdiction, applying these principles of French law as it heard on the evidence in that particular case. My lord, the application of those principles in any particular instance may differ. And that's the job that's normally carried out in these disputes by licensing experts or the likes of consulting economists and so on. Now, that is inherent, whichever legal system you apply, someone's got to do the crunching, as it were. But the question is how one goes about doing the crunching. And that, we say, is an issue of French law here, and it's an issue of Chinese law in China. My Lord, just for your notes, in paragraph 33 of our skeleton argument, we give some references which hopefully will assist on this point about French law. And it was also confirmed by Lord Justice Burse in the Vestel case, and that's quoted in our skeleton argument just over the page from paragraph 33 as well. My Lord, can I move to characterisation more generally as a matter of principle? In Oppo's skeleton argument on appeal, it appeared to say that this question of characterisation is not the correct approach in this case. What it appeared to say, and I think we've heard echoes of this in my learned friend's submissions this morning, is that the dispute between the parties has several distinct parts, and for that reason, the court should instead proceed directly to weighing the relevant factors and determine the appropriate forum for the determination of the FRAND part of the dispute, and that it's entitled to look at that in the abstract without looking holistically at the dispute between the parties. Now, we say that submission is inconsistent with both authority and principle, because there is a sharp distinction between the question of characterisation of the dispute and the question of the appropriate forum for the determination of the dispute that has been characterised. And that must be right, because you can't answer the question of whether there's an available alternative forum for this dispute until you've actually worked out what the dispute actually is. Now, as a matter of authority, the conversant in the Court of Appeal is the legal authority, and my lord's already been taken to that. Can I just draw out a couple of very brief aspects of the judgment which I'd like you to consider, and then you've already been taken to the Supreme Court. So this is the Bundle 2, JA2, tab 27. So if I could pick it up at paragraph 32 of the judgment, so that's on so we're on page 884 in the marking. I'm afraid I can't. 306 in the PDF. So the general principle is that the case, when one's looking at this question of characterisation, is not restricted to analysis of claim and relief, and in that Lord Justice Floyd accepted my own friend's submission, that one must have regard to the totality of the dispute, including, where necessary, the defendant's answer to the claim. And that must be right as a matter of principle, because in some types of case there may be an inevitable answer to a claim. Imagine that there's a patent infringement action. It is very common for invalidity to be alleged as part of the defence to that action. So one's entitled to look at those kind of issues. And it must also be approached in a way that doesn't prejudge where the outcome of the appropriate, where the analysis of the appropriate forum lies. And that is the famous Ree Harrod's, somewhat unfortunately known as the Harman fallacy, which is where one defines the dispute by the relief that is sought. If the relief that is sought is only available in the United Kingdom, and you go, hey presto, the question answers itself. That's not an appropriate way to proceed, because it's essentially circular, and that's the point that was picked out in Ree Harrod. If we could turn through to paragraph 95. And then, so perhaps this is 896 in the bundle, 318 in the PDF. There's then a long section that begins at paragraph 95 and runs through to 104, which you'll see marked in the sort of blue Morse code, which is on. I won't take my lords through that now, but that is an absolutely critical passage, we would say, for this appeal. Paragraph 94.5, Lord Justice Floyd made clear that before you can decide whether the English court is the proper forum, critical initial question has to be asked as to how the dispute is properly to be characterised. And then 95 to 104 we say is very important, especially 99 to 100 and 103 to 104. And then my lords have already been taken to the Supreme Court in Conversant at tab 31, where they endorsed those views, albeit obiter, because there was another way of cutting through the issues in that appeal. Now, so what Oppo has done is arguably the same thing that was the fallacy in Re Harrods. What it's suggesting is you simply reference one element of the relief that's sought, a declaration in connection with a FRAND license, and build the answer into the way it formulates the question. And that's why it's an illegitimate approach, theoretically, to this question of characterisation. But as a matter of principle, quite aside from the application of the authority, what Oppo seeks to do is to hive off what it says is a distinct part of the dispute around the terms of a global FRAND license. But the critical point, as I've just developed, is that that is not a freestanding claim for the determination of a global FRAND license. This is a patent infringement action where the primary questions are whether Nokia's patents are valid and infringed. If they're valid and Oppo has infringed them and is infringing them, Oppo then raises a contractual defence to the granting of an injunction. Now, it may or not be permitted to run that defence. That's an issue that's going to be determined in due course in these proceedings. But an aspect of that defence, if it decides, if Oppo elects not to come off the market, but says it wants to buy a licence, an aspect of that defence is the determination of the terms of a global FRAND licence. So the FRAND issues are not a distinct part of the dispute capable of separate determination. They are an adjunct to the relief that is sought. In effect, what is happening is that Oppo is buying a consent, and the question is what are the terms on which that consent should be brought. And that's, as it were, the theoretical underpinning of this whole case. So, my lord, we say that the judge was quite right in the judgment to approach the proper characterisation of this claim in the way that he did. It isn't that we submit that Oppo is wrong to try and distinguish Conversant in the way that he has. My own friend developed a number of points which he said were matters of difference, but what he didn't do was provide an answer to the general characterisation which Lord Justice Floyd identifies, which is that this is an action for infringement of a patent. Now, what Oppo say is that this is not a case where the technical trials are central. Now, that is news to us because they are being very hard fought indeed. And the first of those is coming up for trial, and it is very, I have a warm feeling that maybe that trial in October will not be quite as hard fought as it would appear to be, but needless to say, everything is being thrown at this case. And as my lords detected, this is as much about timing of the relative actions as anything else. If Oppo said that they want that they accept that there's no utility to those claims, then to fighting that, then we can move on, and we will progress in the action to consider whether it's appropriate for Nokia to obtain relief against them, and we can get on with these issues of whether they're within the class of beneficiaries contemplated by the XC undertaking. And that's the trial that's already been fixed. You don't need to go through the cost of the trials, but to suggest that this is in some way Nokia's, that a vice that lies at Nokia's door is in my submission quite wrong. And the reason being that they are carrying out acts of infringement by selling phones in this jurisdiction. They're not paying for the technology that we have developed. And so we are entitled, subject to the undertaking, and whether they qualify to rely on that, we're entitled to obtain relief against it. Now, Oppo also says it accepts that it requires a global FRAND license. It's asking for a Chinese FRAND license, i.e. determined in accordance with Chinese principles. But the problem for Nokia is that that is not what Nokia undertook to Etsy to give. Now, one of the very striking things you will have seen, you may have seen Miss Liu's second statement in this case. One of the things that we said below was that, in essence, the Chinese proceedings were essentially only advisory, because all they were going to do was determine some aspects of a license. What Ms. Liu says in her second statement is that actually after the Chinese court has determined that stuff, the parties then have to negotiate, and they can either and come to the terms of an agreement, or they could agree to do something else. Now, she then goes on to say that if Nokia doesn't offer what the Chinese court determines, then there are a whole host of different sanctions available, including imprisoning Nokia's officers in China. So there is a very, where one's dealing with a freestanding Frand case with that kind of sanction, it's a very different beast to the English action. And you can see in my submission quite easily how that kind of approach could engage all sorts of issues of comity. But that isn't the approach that the English courts have ever taken to this, because it is always up to the implementer to elect what they want to do. I can't force them to take a license. They may decide to come off the English market, in which case, well, I'll enjoin them. And so that's the point, because the patents are there. They're not forced to do anything. They have to elect. So, my lords, there is no freestanding claim for determination of a global Frand license in this case. It is not a case where Oppo has conceded validity and infringement. That is still hard fought and very much live. And we say it doesn't sit, having insisted that we have to prove and succeed on that, it doesn't sit well for Oppo to now argue that the dispute is in substance about the terms of the global Frand license. They may or not. We may not ever get to that, depending on whether they're entitled to rely on our undertaking to Etsy.
Just as a technical matter, are we or are we not bound by the Court of Appeal's decision in Conversant?
I think it's well. The question is it dealing with the same circumstances? But in my submission, it is binding on this court. The question is ultimately one of whether you can distinguish it on the basis that what arises in that case was different to this case.
Yes,
and we say there's no.
Well, obviously, it was a decision about the facts of that case, but the process of reasoning in Lord Justice Floyd's judgment that you've just taken us to is, to say the least, unscathed by the appeal, subsequent appeal. So, I just think we have to have regard to what our responsibilities are in relation to that, independent of the arguments of merit that we've been hearing.
Yes, well, my lords, I certainly, if my lords are of that view, then another way of approaching that is to say that there's that in any event the ratio of that decision is binding on this court.
Well, if it isn't binding, it's highly persuasive.
Yes, my lord, I think it may be that actually the formal classification of it doesn't particularly matter. But the other point, of course, is that the appeal before the Supreme Court in Unwired Planet was an extraordinarily broad, wide-ranging appeal. And actually, in my submission, it is very notable that the court endorsed that approach, notwithstanding all of the different arguments that they heard over, I think it was four days of appeal in the Supreme Court. Issues about justiciability, about all sorts of issues as well, absolutely live in the Supreme Court. And yet you see that as part of their reasoning. So it is, in my submission, an endorsement, albeit that they do acknowledge that it isn't part of their ratio in that decision, because it isn't necessary for them to decide that, and they have the point about reflexive application.
No, just because something goes on appeal from this court doesn't mean that everything else that happened in the proceedings is wiped out.
No, my lord. My lord, the other, we also say that Oppo's position in this appeal is indistinguishable from that of Xiaomi in the Phillips and Xiaomi decision. We've included that in our skeleton argument. So that's the first instance decision, but you'll see the analysis, I think it was Mr. Justice Mellor, carried out in that. So that's at tab 33 of the authorities bundle. And how Mr. Justice Mellor described it was, he said that there is a sleight of hand in the very foundation of Xiaomi's argument. They focus on the position just before the claim form, which enables them to focus purely on negotiations for a FRAND license and ignore the underlying patent rights owned by Phillips. It's not a realistic way to characterise the dispute or matter to be tried. Without those patent rights, there would be no negotiation at all.
Yeah, well, in the present case, Oppo focused on the position 2 weeks after the claim.
Yes, my lord, yes. But we wouldn't be here if we didn't have any patents, and that's the point which Mr. Justice Mellor makes.
Yeah.
Because there's nothing to negotiate about if we don't have some rights which they would otherwise infringe, absent the consent that they need to buy. So my lord, we say that the judge was absolutely right to characterise the case in the way that he did, and his judgment on that is perfectly sound. Now, the forum convenience appeal is, as you'll see from the grounds of appeal, dependent on having one on characterisation. So if my learned friends are wrong about characterisation, you don't get into forum. And that there's no dispute between us as to the principles of law in Spiliada. I think there's no, so that's the Oppo skeleton at 37 to 43 and Nokia skeleton at 13 to 14. Now that we do place some emphasis on the fact that the threshold for overturning a first instance decision on forum non-convenience is a high one. We put the authorities in our skeleton on that. But we also place reliance on the fact that a number of factors, even if we were wrong about characterisation, a number of factors point to the English court rather than the Chongqing court. This is the usual sort of melee of factors that one has in forum convenience cases about whether the documents are in English or quite what. But we say that, taken as a whole, those support this being the proper forum. And one of those factors that we place reliance on is the appropriate law and the fact that the two disputes are not the same. And the second aspect that we rely on is the relief available in each forum in particular, because the Chinese rate setting claim will not necessarily result in a global license that could be entered into the parties by the parties or enforced against them. And the reason for that is explained in Ms. Xu's second statement, and she said that's the point about negotiation being a necessary requirement after the Chinese court has ruled. So this is Oppo's own evidence as to what's going to happen from their advocate, is that the parties have got to get around the table and try and thrash out a license in the light of whatever principles the Chinese courts determine. So, my lords, I think I can take that pretty briefly in that there are a number of other factors which Oppo identifies, but none of them in my submission assist them. Firstly, Oppo says that the People's Republic of China is an available forum for the setting of global license terms. But even if that's correct, it's not. So I'm looking in particular at Oppo's skeleton, paragraph 58 to 60. Even if that's right, it's plainly not relevant to the question of which forum is the appropriate forum. Secondly, Oppo says that none of the principal parties are English. That is true. This is not Nokia's home court, nor is it Oppo's home court. But Oppo is carrying out acts in this jurisdiction, and Nokia has property rights here, and that is the nature of this claim.
Alleged are two UK distributors.
I'm sorry, my lord.
There are two UK distributors as well.
Yes, exactly, who are domiciled, as to whom the court has in personam jurisdiction. But as I mentioned earlier, we do make complaint about D3 carrying out acts themselves in this jurisdiction. They're operating a website selling the product. So there's no suggestion that it isn't worth suing the UK companies in their own right, and that would be enough. Thirdly, Oppo says that most of its products are sold in the PRC, Now, you have to be a little bit careful about this because my learned friends were talking about sales in terms of, and giving this figure of 0.5%. This is rather reminiscent of the On My Planet appeal, because in the Supreme Court, a very big thrust of Huawei's submissions was essentially how can we be dragged to the English court where this is such a small component of our business? But, of course, the answer to that is you're mischaracterising the nature of the claim, because the claim is not sucking in the parties to carry out a freestanding FRAND determination. The English court is not saying that it is a sort of one-stop shop for global FRAND licensing. What it is doing is it is considering in the course of an infringement action what the terms of a consent are to the patents that are asserted to be valid and infringed. And so it is a very different jurisdiction to the one that the Chinese court is operating.
Once you get into, once you characterise claim in the way you submit it should be, then we don't get into comparisons because the Chinese court wouldn't be an available forum for those issues.
No, my lord, and that's certainly something we rely on because we say that, I mean, the first thing you've got to do is say, is there an alternative forum for this claim as properly characterised?
It's not suggested there is.
No. Well, that's an end of it. A forum non-convenience.
Which is why characterisation is...
Well, absolutely. The only way that my own friends could make any mileage with that is if you're entitled to abstract FRAND, the sort of, as it were, the FRAND aspects of some proceedings and look at them in some sort of supervenient claim, which can then be assessed for forum non-convenience.
I'm just not sure what the applicable principle or authority to support it would be for taking that approach in a forum non-convenience argument.
No, my lord, because we say that actually there's, and Lord Justice Floyd goes through this, there's Utrecht and a series of authorities that say you've got to look at the claim as a whole. What you can't do is slice off chunks of it and then say, well, we could do that bit over there and we could do that bit over there. I mean, it's just wrong as a matter of principle. Quite aside from, and there's a further point which we rely on, which is that even if you did do the slicing off, you're doing a different FRAND exercise here to the Chinese law FRAND exercise that's being carried out in China. So there is a real question as to, even if you could legitimately slice off and extricate that aspect of the claim, whether it was in fact the same thing that the Chinese courts are going on to determine.
Well, from when you took us through the pleadings, it also seems to me that there are some defences which are being raised for which the Chinese court is not an appropriate forum.
No, well, certainly the issues of French law and so on. But
yes, the assertion that there already is a licence.
Yes, absolutely. So
on the face of it would make the Chinese proceedings redundant.
Well, they say that they're in these proceedings, they've already got the benefit of a licence just on currently undetermined terms. And so the question is then, well, how does one resolve A, whether that's right as a matter of principle, and B, what those terms might be if it is right? Well, the correct answer is one cracks on with these proceedings. But that is a defence that they have positively raised here. And that's why, you see, there is a real difficulty with, in my submission with their case, because they are trying to abstract something which is not the argument that they're running here. I mean, it is quite aside from all of the questions of characterisation. Actually, there's a fundamental tension in the way that they're doing it. Arnold, I was going through a series of factors. So the fourth point which Oppo seems to place reliance on is they say, well, the PRC court is already seized with the dispute and is going to get on with it. And the fact that they're already seized, they should just be allowed to crack on. We say, well, that isn't quite right because there is a present jurisdiction challenge which hasn't yet been determined. But even if on Oppo's case that was resolved against Nokia, then at that point Chongqing would be starting their case, having resolved jurisdiction. That's irrelevant to which forum is the appropriate forum for the claim. There is a dispute about the likely duration and timing of the Chinese proceedings. My lords raised that with Mr. Alexander a moment ago in connection with the stay, and I'll come back to it there if I may as well. So we say that point about the fact that the Chinese court has already seized is irrelevant as a matter of principle to the question of forum non-convenience. The fifth, Oppo says, well, we need to try and avoid irreconcilable decisions, and two decisions, each of which fixed a franz rate, would be inconsistent. Now, that may or not be right. We've got to see the decisions first. And my lord earlier posited, well, what happens? Nokia has not anti-suited the Chinese proceedings. We're not saying that they can't continue. The Chinese court will do what it is going to do, applying its principles. But we also say that the English court should do what it should do, applying its principles. But the question is whether the English court should give way. And that's a different question. The mere possibility of irreconcilable decisions doesn't assist one in deciding that. And they may not
What's the nature of your appeals in China?
The
nature of your appeals in China?
So we're appealing jurisdiction. So there are two aspects to that challenge. Firstly, we're saying that it shouldn't be before the Chongqing court, so it should be in Beijing.
Yes, so that's just a question.
That's a local venue
yes.
question. And then the second aspect is a challenge to jurisdiction as to whether the principles in Sharp and Oppo apply to this particular case. So what Sharp and Oppo
principles of, sorry?
Sorry, the Sharp and Oppo decision, which
yes,
was taken to earlier on. So it's identified as
right, so it's a mirror of what we're doing here.
It is to a certain extent.
Right, but so what you're saying is each side is fighting the other's jurisdiction, but so far neither side is seeking an anti-suit.
That's the present position.
Yeah.
What's the international jurisdiction?
We're challenging jurisdiction of the Chinese courts as a whole. Yes.
Not territorially.
Not territorially, subject matter jurisdiction.
Sorry to interrupt. What they're seeking is they're not disputing international jurisdiction. The nature of the jurisdiction they're disputing is subject matter jurisdiction of the sort that was an issue in Unwired Planets, at least in the earlier stages, about justiciability. They're not disputing that some Chinese court can determine this case, if this case is of a kind that can be heard at all.
Right, so it's a more subtle jurisdiction dispute than I first understood. Thank you.
Now, my lord, we also point to various points in relation to forum convenience, the fact that licenses and people will speak English and so on, so you will have seen the submissions on that. So, what we say is that even if the court concludes against us that the dispute is properly characterised as one in substance about the terms of the global friend licence, contrary to my earlier submissions, and the court concludes that the Chongqing court is an alternative forum for the dispute before the English court, then we submit that in any event the court should weigh the factors concerning the dispute in relation to each forum and conclude that the English court is the appropriate forum in any event. My lord, that brings me on to stay.
Are you going to do the respondents' notice at some point?
Yes, my lord. So, well,
this is the argument. The judge was wrong to find that China was an available alternative.
Yes, but my lord, I hope I'd address that slightly in the sense because that's a question of whether it's an available alternative for the action within the United Kingdom. So but I can come back to that as a specific point if
Well, that's the point you went over with Lord Justice Phillips, namely that if the judge is correct on characterisation, it necessarily follows that there is no alternative forum.
Yes, right.
Because it's accepted that the Chinese court will not be touching the UK patents with a barge pole.
That's the point, yes. And if we were to sue in China, this is the point that was made in Conversant, we would have to sue on our Chinese patents, which may or not be very likely to be different patents raising different issues of technology.
Okay. So that's been taken in. Thank you.
Yes, my lord. I'm grateful for that. Now, the question of stay. There is a logical problem which my lord's identified earlier on in Poe's position as far as the stay is concerned. But when one's approaching this analytically, one has to ask, first of all, as a matter of case management, it is clear that the court has a wide discretion. No one's disputing that as a matter of case management there is a wide discretion. But, and the judge considered various discretionary factors that were raised by the party and balanced them up and refused to grant a stay. So there are two sub-issues that are engaged in relation to the stay appeal. First of all, did the judge err in the exercise of his discretion, such that his discretion should be set aside? And secondly, if he did err, how shall this court re-exercise the discretion? Now, in order to disturb the judge's discretionary decision, Oppo has to show, first of all, that he erred as a matter of principle, and that we say is a heavy burden. Oppo first submits that the judge erred because he acted on an incorrect principle by improperly narrowing the test. So he approached the decision on the basis that it involved a balance of prejudice or lack of prejudice, and that the parties, and that a decision made on whether the scales were tipped, it says. So he was looking just at that narrow issue of prejudice. And it says that Reichhold, in fact, requires the judge to ask the wider question whether it's in the interests of justice as a whole for a temporary stay to be granted, and so on. And we say that misconception is that criticism is quite misconceived. The judge, when you look fairly at the judgment, did not read Reichhold as requiring only a balance of prejudice or a lack of prejudice to the parties. What he did was correctly read Reichhold as requiring a conclusion on the balance of justice, with particular reference to the savings of cost and convenience of the parties. That's the judgment at paragraph 120. So that is absolutely square with the ratio of the Reichhold case. And then he went on to say that in this case, the balance of justice will turn largely or entirely on the principle of prejudice to the parties. That's the judgment at 120. So in other words, what he was saying is that taking all the factors that were relevant in making a case management decision, the most relevant factors in this case were the prejudice or lack of prejudice to the parties. There was no evidence before him about the relative costs of proceedings in the other forum. Well, as a friend somewhat essentially made a submission today that it was quite expensive, but I think you'll be getting a feeling, well, you will have seen from the papers the sums of money involved in this action are very substantial. And so, again, these are hard-fought cases where those costs are not substantial relative to the overall sums that might be otherwise due by way of a license. And that is one of the reasons why often an implementer will hold out. This is a particular phenomenon which was considered by the Supreme Court in the OnePlus case, because a rational implementer will take a decision to delay payment of very substantial sums in order to do two things. Firstly, because they don't want to part with money any earlier than they need to. But secondly, they actually get a competitive advantage relative to their peers if the others are paying for a license and they're not.
Well, in many businesses, litigation is completely extraneous to conduct of the business. Very bad luck if you get involved in it and you get in and out of it. As a newcomer to this industry, it seems as if litigation is completely built into the business. It's almost part of the business model.
Well, the implementer, certainly for the implementers, they don't want to part with money unless they're forced to. So
no, but I mean, when one looks at the slew of litigation that seems to go on continuously, it's just one part of the manufacturing process.
There's a famous judgment in the 19th century where I don't remember who it was commented that he rather wished that his entire family went down with influenza than have to fight a patent action.
Lord Esher.
Yeah, Lord Esher, I'm grateful, my lord. This is, I mean, that may be opposite here, but I'm afraid that one of the realities of this is because there is no predetermined dispute resolution mechanism.
So until the business model changes,
yes,
this is what happens.
Well, it is, but of course the other thing is it's a very fast-moving market, and in order to, if you build a phone, you're working a very large number of patents owned by all sorts of different people. And so the question is, you've got to go and take a license to those on fair and reasonable terms, or wait until they catch up with you.
So anyhow, the emphasis seems to have been on the poor judges of the Patents Court, rather than on the shareholders of the companies and their ability to afford continuous litigation of this kind.
Well, when one considers I'm afraid the reality is, although the costs are large in these cases relative to the sums that may be due if you're selling a lot of products, it's actually...
Yes, but it was suggested that we might relieve the burden on the patents.
No, exactly. My Lord, I think Mr. Justice Mead will no doubt be very sympathetic with that view, and has hinted already in this case that he was struggling to see the utility of the technical trials. That's something that we'll have to come back to in due course. But it is a question for Oppo, as my lords have already identified.
Yeah,
I mean, we've
been over that a number of times now.
Yes, I mean, there is a bigger, broader case management issue about whether it's appropriate for all of these cases to clog up the Appellant's Court diary in the way that they do, and
That's
whether
not
there's another way of doing it.
Sort out in
Yes, I mean,
this appeal, is it?
No, that isn't an issue on this appeal, as my lord identified. So my lord, the judge correctly considered the principles in Reichhold and rejected the case management stay at 127, paragraph 127. And we say his decision was plainly justifiable and within the generous ambit of discretion entrusted to the judge following earlier authority. Now, it's also suggested that the judge's error was in part founded on what's been described in Oppo's skeleton argument as a deductive fallacy, where he suggested that by staying the English proceedings, one would always save the court's time. Oppo said that the judge looked at matters in an insufficiently case-specific way, and that he should have considered the time and resources that would be saved if the English court did not press on with multiple patent trials. That's Oppo's skeleton at 69. But we say that criticism is also misconceived. The judge did not say that the saving of court time was a relevant factor. He said that the saving of the court's time was not in and of itself capable of justifying a stay, because a stay always involves the saving of the court's time. If you're getting rid of the case, the court can go off and do something else. His decision on that was, we would say, unimpeachable. And then finally, Oppo submits that the judge erred in holding that none of the factors tips the balance of justice as between the parties in favour of stay or no stay. And as my lord has already identified, this was effectively a no-score draw point. But that, in my submission, was an entirely orthodox approach to take to this question as well. And in Reichhold itself, Lord Bingham explained at paragraph 186 that stays should only be granted in rare and compelling circumstances. So a convincing case is required for a stay to be granted, and where the relevant factors in a particular case are evenly balanced, the discretion should be exercised against granting that stay. And we cited authority for that in our skeleton argument. That is essentially what the judge concluded. Now, my lord, my own friend Mr. Alexander has advanced a new argument here, which is that you should let China go first and then let the English court fix things. So this is now we don't we did object to that as a proposal coming before the court, but it's here now. It wasn't that kind of step-by-step approach was not something that was live below. What was live below, as my lord has already seen, was the proposal that Frand was separately stayed, so carry on with technical trials and just stay Frand. It was not a Frand sequential approach. But we do have a number of concerns with the approach that Mr. Alexander has just developed. In particular, it does seem to be a rather not really thought through approach, because quite how it is contemplated that this should all work, what I think he's proposing is that the English court should down tools, wait for China, and then spring back into action, where we can then have an argument about whether UK or EU rates should be different. So all of this will then be seized back before the English court. No doubt there'll be appeals and so on. But why EU and UK? Why not India? Why not the United States? Why not Indonesia, where Oppo make a large number of products, and so on? So, and there are, as you will have seen, actions in Indonesia and India as well. So we don't say that that's a satisfactory outcome. But again, as a matter of principle, it's very difficult to see how it can solve the problem in a sensible way. Because the point about stay, as my lords, through your interrogation deduced, was that the point was essentially one of timing. But that is an argument that could always be run, as my Lord Justice Arnold identified. You just go off to the quickest jurisdiction, be it Texas or wherever. You probably won't go to Italy, because that was famously the torpedo that ran very slowly. But you will, the question, should the English court always give way to a jurisdiction that will run quicker? Well, that's not a principled basis on which to approach a question of stay in a case like this. But even more so, where the effect of the stay is to shut Nokia out of relief for its valid and infringed property rights.
What part did this step-by-step, as you describe it, approach play in the hearing below?
Oh, so, my lord, that wasn't in the hearing below, the step-by-step.
No, I understand that, but I mean, I'm just wondering why it's then available to us. I mean, well, I'm giving you, of course, there'll be a reply, but on the face of it, if an argument hasn't been, if the judge hasn't had an opportunity to deal with an argument, because it hasn't been made to him,
yes, it's very difficult.
We've no business to be dealing with it.
We shouldn't criticise an exercise of his discretion on a matter that wasn't raised before him.
I'm suggesting that the principle may go broader than that, namely that we would have no business in overturning him in relation to an argument or possibility which had not been argued.
Yes. My Lord, I think there's a I can't remember the name of the case, there's a very good judgment by Justice Lewison on new arguments being raised for the first time in the Court of Appeal. There's a famous quote about...
Yes, Phage.
Yes, that's one, Phage and Chaban.
Yes, mentioned in every second appeal.
Yes.
Yes. Not in this one. Yes, yes.
It's a case that's cited, constantly cited, but nothing ever seems to turn on the exact quote, except when because it's the same principle applies here. If they didn't raise the stay argument below, this particular stay argument, they shouldn't be entitled to do it now, because it isn't about a criticism of the judge's reasoning or his balancing of the discretion.
But just returning to what was in issue before the judge, Lord Justice Peter Jackson pointed out earlier that if you look at paragraph 49, the judge there tells us that the primary application was for a stay of the whole proceedings on case management grounds, and then by way of fallback, there was the suggestion of a stay of the Fran proceedings, allowing claim for infringement along with related issues on essential infringement to go ahead. And he says argument focused on the latter. I mean, there's a small linguistic point there which he doesn't actually mention validity. It's a query about that. Let's assume validity would also go ahead. But actually, when you look at the reasoning, it doesn't really seem to reflect argument in which there is anything substantive happening in this jurisdiction. So yes, no doubt, I'm not questioning what the judge says at all. No doubt everybody was discussing Fran. But, as I think we discussed earlier today, the practical reality seems to have been that even so, if you were going to stay Fran, you would stay everything.
Yes, I think...
And that was very much the approach that was taken in the appellant's skeleton argument.
No, and that was certainly my learned friend Mr. Leighton below was advancing the argument that the stay was a stay of the entire action. He did have, it is quite right to record that he did have a fallback position, which is that if the technical trials could crack on, I think the reasoning behind that was that the English court is seized with issues of infringement of English patents, but all the Fran should be parked. But the point was that it was parked forever. It was not. His case was not that it is parked then reactivated, which is the point that
that's the
Mr. Alexander. That's the new point. That's the new point. It's the sequential aspect of it which is here. That wasn't something that was raised below, and that we first saw that in a letter that was sent to us just before the hearing of the appeal, and that was accompanied by a request saying that they wanted to put that letter and our response to it in the bundles, to which we said, well, that's not live on the appeal, and it's now worked its way in through these additional submissions.
Right, so there was an argument that it should be, that the Frand element should be stayed, but there was no argument that it should be stayed and revived.
That's it, yes. So stayed in perpetuity rather than stayed and resurrected.
Well, I'm relying on my memory because I was on my feet making these points before before Judge Hacon. My recollection, and maybe the transcript will prove me to be wrong in my recollection is that I said, well, if you're not going to stay the whole thing on forum grounds, then you should stay it on case management grounds. But what you can also do is you can stay the Frand part of it. My recollection is that it was clear in that discussion that the English court would get a second bite of that cherry if it needed it, if it didn't like the terms that the Chinese had handed down, very much along the lines of the One Planet license.
Right, well, I'm sure that there's a lot of paper evidence of what was going on. So if there's any reference in the documents that were before the judge to that possibility, we'll obviously see it.
Yeah, for our part, we don't have any recollection of that, but my own friend will be Arnold, so the stay we say doesn't it's very difficult to see how there is a principal basis on which to criticise the judge's reasoning on the stay. But in any event, we say there are 7 factors that militate against the granting of a stay, which I'll run through very quickly.
Well, is your overarching argument not that if you had succeeded on the jurisdiction issue, then it's very difficult to see on the facts of this case how there's room.
Well, what does the stay give you?
How there's room for success on the first issue for you, but failure on the second.
My lord, exactly.
Right. Well, you're going to go on and
well, I'll give you
egg this.
Yeah, yes, if I can, as it were, scramble.
What are your 7 points?
So 7 points. So English court applies French law. That's the first point. Chongqing court applies Chinese law. That's important because French law and Chinese law adopt different approaches, and that's relevant.
Right, just give us the list.
Yep. Number 2, Chinese rate setting claim will not resolve the dispute in terms of the global phone license because it's deficient in the respects identified earlier. So no cross license, Oppo branded devices only. The relief available in each, number 3, the relief available in each forum is different. Number 4, we do say it is relevant that the English courts have more judicial experience than the Chinese courts in this area. I know the friends refer to the Chinese courts, but they have chosen to seize a court that has never done this before, as opposed to the Shenzhen courts who have. Now, we don't know why that is, there's no evidence on that point, but that is, we say, a factor to be taken into account. 5th, English language is central to the issues in the case. 6th, we also place weight on the issues in our skeleton argument relating to arbitration, and that's the confidential part of the skeleton at 69 to 71. So you've got those submissions. And 7th, we say there's nothing in the point about irreconcilable judgment.
Because?
Well, my lord, because that is not something which will necessarily arise in these proceedings, but in any event...
Yes, but we're always concerned with the risk of irreconcilable
No, we are, my lord, and I can see that, but the risk is one that one could see in every single case in this area. But it isn't a necessary risk. But there's no basis, we would say, for the court to assume that decisions in the English proceedings and the Chinese proceedings will necessarily be irreconcilable with each other. The judge below held at 75 to 76, the courts may differ as to Frand terms without their judgments being irreconcilable.
So what is it? If the parties won't go to arbitration neutrally to start with, then they end up with different, shall we say, whether they're irreconcilable or not, decisions. And then they have to go to neutral arbitration to make their businesses functionable.
Well, so they end up with decisions, but if the decision is the same as the decision in England...
No, I'm talking about where it isn't.
Well, but I don't mean, so I mean the basis of the decision, sorry, my lord, I don't mean the result. So imagine that the English court determined that Frand was $1 and China said it was 50 cents. In the English proceedings, the question would then be for the implementer to decide, do they want to take that license or do they want to come off the English market? So that's an election that they're put to. So, and that is because the patent relief is territorially limited within
Yes,
the
but
United Kingdom.
that assumes an all or nothing approach. That I mean, in the end, clients in your respective positions, both sides, have a common interest. I mean, you have a common interest in getting money out of the public, and so going out of markets and so forth, presumably, is a nuclear option, but it doesn't suit either of you to do that. So, I mean, in the end, it just seems every road leads to some form of dispute resolution.
Well, my lord, I think holistically, yes, potentially. But the other point which is also important to bear in mind is that depending on the nature of the proceedings, a patentee may or not decide to offer the license that has been determined. If you imagine the Tuvaluvian court or the Ruritanian court or whatever going off and deciding that a Frand license applying its principles was 1 cent on a global basis, a patentee may say, subject to issues before that court, that they don't want to offer that license. And they'll say, well, we'll take the consequences in Ruritania. And so that's another aspect of the sort of the international, the way that all of these things play out. Because
I'm not sure I understand that submission. So the patentee is given an undertaking to Etsy to license on Frand terms. Now, I can understand that the patentee might take the view that a court has set terms which are not Frand. But if we hypothesize that the terms are Frand, what are you suggesting?
well,
the patentee will not comply with its undertaking?
No, my lord. I think if the terms are Frand within the meaning of the undertaking under French law, then the patentee would potentially be, well, acting inconsistently with the undertaking it had given. If the Ruritanian court went off and did its own thing under Ruritanian law, without regard to any of the principles under French law, or the patentee's undertaking, the proper construction of which we would say is a matter of French law, then that is something where that undertaking would not be engaged. And in those circumstances, the patentee may take the view, well, that isn't a Frand determination of the sort that was envisaged by my undertaking to Etsy. So therefore, that is not one that I will endorse. But I mean, obviously, that is a very serious matter for a patentee as to whether they went down that route. But it is another aspect of this whole dynamic, because it isn't necessarily automatic, having declared, particularly where a court is exercising a freestanding declaratory relief, that the parties will then come together and enter into a license on those
Well,
particular
I
terms.
can understand the proposition that the mere fact that there's a court decision doesn't logically entail that the court has applied the law correctly. The court might have got the law wrong. It's one of the reasons why you have appeal courts, apart from everything else. But leaving that aside, I don't quite see where that leads to in terms of consequences. I mean, yes, you can say theoretically, if the court hasn't applied the law correctly, therefore it hasn't determined Frand, therefore the patentee, at least at the level of theory, isn't bound by its undertaking, at least with regard to that decision. But where does that take you?
Oh, well, my lord, the only point I was seeking to make was the fact that it isn't necessarily automatic that a declaratory determination by a particular jurisdiction will necessarily result in a binding license on a global basis, because it takes two to convert the declaration of the terms into a binding license. An agreement has to be reached in respect of the determined thing. And so it's just to emphasise that there is that separate step. A separate point.
Why is that not equally true of the English proceedings? So let's assume for the sake of argument, you have a scenario whereby an English court has found some patents in a portfolio valid and infringed, and it has determined what terms are frowned. And the implementer, having considered that, says, all right, I will take a license on those terms. In theory, it's open to the patentee to turn around and say, well, I don't accept that those terms are in fact frowned. I'm not bound by my undertaking. And I'm not going to enter into a license of those terms. But then the consequence of that is they won't get their injunction.
Yes. So they're deprived of the effect of their property right. And so does your submission amount to more than this? That actually, at the end of the day, you can never force either side to the dispute to enter into a license agreement that they don't want to enter into, because each side has the alternative of, on the one hand, withdrawing from the market, or on the other hand, giving up its property. Yes, being told it can't, for the patentee, being told it can't enforce its rights.
Yeah.
Well, so yes, that's the submission. I mean, the other related point, which is important to bear in mind, is that obviously the undertaking to Etsy is that the patentee has to offer a FRAND license within the FRAND range, not necessarily any particular determined license. So it is perfectly possible, and one of the issues which could potentially arise in these sorts of cases is whether it's appropriate for the patentee to say, right, well, if my obligation is that I have to be within this penumbra of permitted FRAND outcomes, I can choose to offer you the most expensive one, as long as it's within the safety net of what is properly FRAND. That may or not be the same as the determination that was carried out elsewhere. And that's a consequence of the fact that, following the Court of Appeals ruling by Lord Justice Kitchen, as he then was, FRAND is a range, it is not a point, as Mr. Justice Peirce, as he then was, decided. Now, my Lord, all those points, I'm not sure anything really turns on them for the purposes of this appeal, but they are, as it were, aspects of the dynamics of this on a sort of international plane, which are perhaps material to the question of how one ends up in situations where you may end up with different determinations. My Lords, I think unless you have any further questions, those are our submissions. For obvious reasons, we say that the appeal should be dismissed.
Thank you very much indeed, Mr. Sanders. Yes, who will reply?
Well, may I make 3 short points and then leave the floor to Mr. Alexander?
Yes, by all means.
On the forum question. Well, first on the question of whether this court is bound by a decision which is subsequently altered by the Supreme Court on that question. But if this case were on all fours with Conversant, and if the reasoning of this court in Conversant remained undisturbed, well then of course you would be, even if the result were different. We say actually the Supreme Court said that the way that the Court of Appeal had approached it was not the correct way, but the correct way to approach it was to see that there was no alternative forum, and that was the basis of their decision. If you, however, conclude that there is an alternative forum, so that argument doesn't run, in this case, and we say that now there is an alternative forum, then you come back to the question of whether it's on all fours. And we say it's not, for the reasons that I identified before. My own friend has been at pains to say the dispute here is not the same, and in doing that he has closely examined the tail of the elephant. But he has not examined the shape of the elephant as a whole, and the elephant as a whole is what the court should, with our respectful submission, be looking at for the purposes of characterisation. It is, with respect, unduly parochial to look just at seeing what it is that is in issue in this case and seeing whether that precise points are an issue in China. The dispute as a whole is to look and see where the real meat of the argument between the parties is. He's right. On our defence, we put in arguments that go into the essentiality and validity of the individual patents. That's right. But it's still only a point about the tail of the elephant. It's not a point about the elephant as a whole. And if you look at the elephant...
I mean, your point, to understand it, is that you're, because of the consequences of taking a different view, bound to raise those defences, because the consequences of you not running them would be disproportionate.
Yes.
Because a decision has been taken that we have global reach.
Yes, and Mr. Alexander made those points this morning. There is additionally the point that the licence is proposed for 3 years, but the patent is longer. If we had accepted and not disputed the essentiality, validity and infringement of a particular patent here, with a view to getting on with this case here, in 3 years' time we'd have no answer to a claim for an injunction. And so, because of the
License
peculiarity...
doesn't have to be restricted to 3 years. There's no rule of law to that effect.
No, but it's a commercial reality. I'm told, your Lordship will know that better than I do, but the commercial reality is that parties don't want to enter into licenses for so long because it's a rapidly changing market. Today's big players...
Sure, but they might enter into 4 years or 5 years.
They might. They might. But in this case, it's proposed and people are negotiating for a 3-year licence in respect of patents that have longer lives. And so we would be foregoing a defence against the very point that is being argued about here being repeated in 3 years' time if we didn't take a stand on that. The question of whether the dispute's not the same, if I can come back, I have to say one further thing about that. That might be a legitimate inquiry if we were concerned only with licensing terms for the United Kingdom or for Great Britain, or even for Europe. But here, the consequence of not seeing this as a global dispute between the parties and seeing it just as a question about, or characterising the claim as a dispute about a local patent, is to lose sight of the larger truth and to allow that local characterisation to define the shape of the global dispute. And the argument that says that you should characterise this by reference to the global dispute is the one that we say should prevail in this court. Now, Mr. Alexander has answers, I think, on the other points.
Thank you.
My Lord, can I very briefly deal with the 7 points that my learned friend made in relation to the case management stay aspect, and then come back to whether there's a basis for your Lordship's taking a different view. The first point was that the English court would apply French law and the Chinese court would apply Chinese law. That was actually dealt with by the judge, in our respectful submission, entirely correctly in the judgment on this, where he considered whether or not this would actually make any difference in this case. He dealt with that in paragraphs 99 to 106. My Lords, he analysed it in considerable detail and made the very point made by my Lord Justice Arnold in relation to whether or not this potential difference in evaluation was actually an issue of French law at all. That's not the way in which this issue was actually addressed in the Unwired Planet case. The second point that the judge had well in mind on that issue was the extent to which this matters at all. And it may not matter on either side's case. He said that in paragraph 106, that's called bundle 131, although the Chongqing court will very likely assess Fran terms, including royalties pursuant to Chinese law, was not shown the expert evidence that this would involve a concept of Fran different from that adopted in other jurisdictions. Even if it's the case, it was not explained to me why the difference matters. And the reason that the difference may not matter at all is there may be no, for example, issue in relation to whether or not a particular alleged discrimination with a given license was with the most favourable license or range of favourable licenses, or whether indeed even the evaluation was undertaken by reference to comparable licenses at all. So the point simply may not arise. And our submission in relation to that, insofar as it relates to the case management stay, is, well, that's a classic situation where one would want to wait and see. If the Chinese court came up with a determination that was inadequate, then a stay might be lifted in the way that I contemplate, and I'll come back to that point in relation to whether that point was raised below shortly. But one can't assume that the Chinese court is going to get Frand wrong. Indeed, the learned judge held that the Chinese court was likely to settle a Frand license. And in our respectful submission, it's not good enough to say, well, I don't like the terms of the license. Indeed, one of the premises of this entire debate is that different courts may approach things in a different way. That's the premise of these debates in all of these licensing disputes, whether it be in the context of these sorts of licensing disputes, compulsory licensing disputes in different countries under different under equivalence of patents. Different copyright tribunals in different countries may evaluate the rights for their particular territories in different ways that others may do. It doesn't mean that they're not making a Frand evaluation. When one is concerned with whether or not there is an evaluation on a global basis, unless one is taking the very strong view that says, well, you're simply not allowed to apply your local considerations to whether or not terms are Frand, which in my submission no court has done so far. Indeed, quite the opposite, because they contemplated that they would take into account what Chinese courts would do and indeed potentially build them in to an English Frand license. This point doesn't go anywhere. And so the judge was right to find that that was not a point that supported my learned friend's case. Second point that's made is that the Chinese rate-setting claim was different and it was deficient and would only deal with branded, with certain goods. And the learned judge dealt with that in two ways. First, in relation to whether or not there would be a license settled for the cross license. And he dealt with that at length in paragraph 78 to 92 and concluded, in effect, that in 92 that he didn't find the notion that Nokia could raise the cross license in a pleaded claim at all surprising. I accept the evidence. I think it's likely that if the claims of the Oppo plaintiffs go forward in Chongqing, it's within Nokia's control to ensure the Chongqing court will consider the cross license and its effect on net royalties payable by the defendants. So it's not the case that the Chongqing court would not consider that. It's entirely within Nokia's control whether or not that would come in. Similarly, in relation to the point made on licenses for devices other than Oppo-branded devices, the judge again dealt with that in detail between paragraphs 93 and 94, where he said, and ultimately accepting the evidence, and assumed that a Frand license to be settled by the Chongqing court would include devices other than the Oppo-branded devices. And obviously, it's logical for that to be the case. The third point that's made is that the relief that's available in different fora may be different, and indeed that may be so. In this country, if a license is settled and is held by this court to be Frand, the relief that is then provided in relation to that is that an injunction will be granted unless a defendant enters into a license on those terms, subject to appeals and subject to any other discretionary factors that may arise in relation to that. One discretionary factor, of course, might be, as my Lord Justice Arnold has indicated, that if a claimant, having said, I'm going to offer a Frand license, the court then settling a Frand license, then says, well, I'm out of here, I'm not offering you that Frand license at all, then the court might say, well, in that case, I'm not granting you an injunction to restrain infringement if you are not prepared to offer the license that you have undertaken to give and gone through the trouble of asking the English court to settle. It will ultimately be for determination, possibly either on what has been called Trial E in this case, which is a trial concerning what undertakings should be given to the English court in advance of a Frand case, whether it is sufficient for my clients to give an undertaking or to have given an undertaking to take a global license, that is to say a license that covers inter alia the United Kingdom patents, settled by the Chinese court. That is one of the big issues outstanding in this issue. And the reason it is a big issue, my lords will of course appreciate, is that if the English court says, well, the only tribunal whose Fran determination we will accept to be Fran, so the only tribunal to which you can give an undertaking to take that tribunal's license and only that tribunal's license is the English court, and all other courts say the same, applying the same approach, you just have the same clash, but down the road. Moreover, what that would do is it would, in some sense, delegitimize the very idea of a foreign court determining Fran terms globally, because what it would then say is, well, notwithstanding the fact that a foreign court says it's appropriate for me to do this, I am going to do exactly what the English court says at the suit of the, in that case, notional implementer, or in this case, SEP owner, because both sides, one has to remember, we're not just defendants in this case, we are claimants under our own set of 5G SEPs. We've been making contributions to this standard in the same way that OPE has. If that said, and it said, well, you can only enter the English market if you agree to a license in respect of acts in China under your own patents that's settled by the English court alone, otherwise your products will be excluded from the English market, that raises very fundamental questions, including as to comity. So in our respectful submission, the fact that the relief may be available in different fora doesn't address the issue at all of this aspect of the case, which is the order in which proceedings should be determined. The next point is the one about experience of the courts. Now, it is true that actually relatively few courts have experience of actually settling Fran terms. We have one judgment.
Well, you have the judges with you on this.
Oh, indeed, and that's what I was going to say, was the judges already decided that. The English language point, again, the judge was with us on that, and we say he was rightly with us. Arbitration, I think I've really addressed that matter at sufficient length, but I just want to make one further point, since it was referred to in my learned friend's opening, and you will need for this the supplementary bundle. And I hope I can do this without doing anything confidential, just showing my lord the document, and I think you may have this in mind. It's at page SB 305, tab 31, and
yes, we looked at this.
I think your lordships have already looked at it, and you will, I hope, have in mind that what was proposed was, if I may put it non-confidentially, two things, and one of those two things is being done. So if and insofar as it's being said, well, you are not doing what was proposed, we respectfully say that is a one-sided way of putting that. And my learned friend Skeleton, of course, refers to the fact that we did not agree to do one. Well, in fact, we agreed to do the other, albeit somewhat later. So that particular point in our respectful submission does not go anywhere. The final point, which again the judge dealt with, was the irreconcilable judgments. And again there we respectfully submit he was rightly with us. He dealt with that at paragraph lost my reference, 75 to 76, and concluded at 76 that the points may differ, the terms may differ without the judgments being irreconcilable. We respectfully agree on that point as far as it goes, but again, it doesn't touch the question of what order proceedings ought to be determined in. And when I say order, whether one proceeding ought to be stayed pending the decision of the other court. So can I then come on to this issue of sequencing of proceedings? In the skeleton below, which I'm not sure I've got copies of here, but I can read out at least the relevant part, because my lords were questioning.
We're on the stay and revive issue.
Indeed, stay and revive. What was said in the skeleton, and I'm afraid didn't have this in mind. I didn't appear below. Following the PRC determination, defendants will be licensed on the terms found FRAND by a competent court. There ought to be an end to the dispute, but even this would not prevent a further FRAND determination in the UK if deemed proportionate and appropriate for the UK court to consider the rate to apply for acts undertaken in the UK as part of the global license settled in China. A similar point was made in reverse by Henry Carr, J. and Conversant at paragraph 65.
Right, so you're reading from paragraph...
I'm reading from paragraph 108 of the skeleton argument before the learned judge. And the learned judge did actually advert to that, to this point in the judgment, and I can just show my lord the point to it. He didn't advert to it in quite these terms, but I think it's probably right that this is what he was referring to. And it's in paragraph 123 of the judgment, where he says that the defendants say that Nokia could ask the Chongqing court not to settle FRAND terms with the UK, leaving that to be determined by this court. Not obvious to me why the Chongqing court would agree to do that. Both sides have said that they would like a global license. If the UK were carved out, why not Germany, India, and Indonesia, or any other territory that Nokia may wish to list? It would make a nonsense of the preferred solution of a global license. And of course, my lords, anything that is a diversion or a derogation, perhaps is a better term, from absolutely single, monolithic, single forum settlement of a license might be said to be undermining the principle of single forum licensing. But in the state of the world that we are in patent FRAND terms, and given the fact that the English court has itself recognised that it may be appropriate to take into account what other courts are doing in relation to this, to have an approach that says, well, all right, the Chinese court should go ahead, and if it is necessary, then there can be an adjustment. The court there put it in terms of a carve-out, is a reasonable approach. Now, it is true, my lords, and I don't want to suggest in any way that, that the judge was should have taken our most recent proposal into account. Obviously not. We have made a modification to that approach, which is in a sense more favourable to Nokia, where we say, well, actually, you, Nokia, don't have to ask the court for a carve-out of this kind. We're prepared to undertake to proceed on the basis of this carve-out, and we are also prepared to undertake to have those terms apply not only for the United Kingdom, but also for the EU. Now, my learned friend says, well, why not other territories? Well, our primary position is that this is a license that ought to be settled or the terms should be settled in China. And if we make, as it were, a concession, say, well, all right, you can have this local rate setting, that is not an unreasonable concession. And it has a number of aspects to it. And one of the aspects which we say is one of some relevance is that if that were done, then it would potentially make all of these further proceedings unnecessary. So I come back then to the final point, which is where my learned friend started on this, which is there a basis for my lords taking a different view from that of the court below in relation to case management? And although my learned friend has quite rightly drawn attention to the high hurdle and the factors that were taken into account by the learned judge, what in my respectful submission his argument didn't grapple with was the fact that the judge didn't really look at this in terms of timing of proceedings at all, of saying, okay, well, this proceeding ought to go first and then we ought to have the later proceeding. He was looking at this matter on the basis of what are the alternative fora, and one can tell that because he starts off the discussion in paragraphs 115 and following by considering the fundamental question, which is that this doesn't, the way that the jurisprudence is developed, doesn't determine which of the tribunals should be settling the license. If one starts with the assumption that there should be a single tribunal settling all of the Fran terms. So in our respectful submission, if my lords are persuaded, and my lords would have to be persuaded, I think, in this way round, that this is a case where it would be preferable for there to be case management so that China went ahead first, one saved the cost and time of the English proceedings initially, and then took stock, there would be ample basis for my lords reaching that decision and holding that the court below had not actually analysed it in that way at all. So in my respectful submission, the basis of our argument remains as it was. This is an issue of genuine practicality. What is one going to do? Is one going to say, well, yes, everything should go ahead in parallel, which is the Nokia preferred position, or should one try and order these proceedings in a way that at least tries to save the cost of one?
Preferred proceedings is that they don't go ahead in parallel.
I beg my lord's pardon?
I think their preferred position is they don't go ahead in
Oh,
parallel.
yes, of course, not Nokia's ultimate
Yes. No,
preferred.
you're both firm adherents of the one court principle.
We're both adherents of that, but I think in terms of the procedural aspects of this appeal, which are, should there be parallel or series, Nokia's preferred approach is of course, a parallel approach. So I think unless I can assist my lords further, those are our submissions.
Thank you very much. Very well. Well, can we thank you all for the care that has gone into the preparation of the appeal. We will reflect and let you have our judgments in draft for the purpose of editorial corrections only, and the agreement of a draft order to reflect our decision. If there are any matters that you're unable to agree, we'll deal with them on paper, unless we decide otherwise. And the finalised judgments and orders will be handed down electronically, as has now become the norm. Thank you very much.